Hello, this is Antonio Gangale. We'll be discussing the United States of America versus Union Cheese Company. We'll be discussing whether there was criminal misconduct by government actors within the case, whether there was willfully depriving of rights under the color of law, and conspiracy against rights within the case, whether the June 16th order and the January 23rd judgment, whether it's void. We'll be examining the issues of whether the declaration by John R. Marzilli of named individuals, if it was false, untrue, misrepresented, and/or inaccurate. Further, whether the FDA zero tolerance policy in the processing area, while the FDA surveys report 13% of the commercial raw milk supply has listeria, whether that conflicts with well-established law, the standards of identity of natural Swiss cheese, and if it deprives the rights under the color of law. Further, we'll examine whether the declaration of Joseph M. Madden was it legally insufficient, and with regard to that, whether Joseph M. Madden's, the expert witness's testimony regarding the possible levels of listeria in the milk, whether that was false by omitting that Union cheese had methods of using the high temperature short time pasteurizer process. Further examine whether the Declaration of Phillip within the plaintiff's memorandum in opposition to defendant's motion to drop the party, whether it materially omits multiple official records prepared by the FDA indicating that Annette M. Gangale, the title was a secretary. Further, we want to mention if they omitted individuals within that declaration as well. And lastly, whether the FDA spokespersons publicly misrepresented the mandates imposed on Union Cheese Company, while the FDA's own compliance officer privately, in a June 22nd call with a major co-op, informed that it was going to be virtually impossible to resume cheese manufacturing operations. These declarations were filed under perjury of 1746. The false declarations are also in 1746 under the statute. False statements, deprivation of rights, conspiracy to deprive rights. So here, knowing a false statement need not be made with the intent to defraud, or there is an intent to mislead or to induce belief. Reckless disregard of whether the statement is true or a conscious effort to avoid learning the truth could be construed as acting knowingly, proving that the defendant either knew the statement was false or acted with a conscious purpose to avoid learning the truth. Proof that the defendant acted with reckless disregard or reckless indifference may therefore satisfy the knowledge requirement when the defendant made a false material statement or consciously avoided learning the facts or intends to deceive the government. Whoever a person having makes a statement with reckless disregard of the truth or the statement and the conscious purpose of avoid learning the truthfulness of the statement is deemed to have knowledge of this statement and its truthfulness or lack thereof. Here the statute also covers half-truths, where the duty to speak the truth, concealment of material facts. A couple years after the shutdown, several people had suggested that I should write a book regarding the events that transpired. So I was gathering the information. I was going to dedicate it to one of my employees who passed on August 6, 1995. From my perspective, the order did not seem possible, and it didn't seem that they were equally applying the law, and there was just a lot of issues in the case. While I was going through the material, found the actual complaint within this matter, and while going through it, I had discovered within the statements of fact that they were underlined, and some writing in the margin that appeared to be stating not me, that was next to my father's paragraph. When I had read them, that's when I understood and why I just couldn't understand some of the facts and stuff. So it appears to me that these declaration or the statements of fact, which were from the Declaration of Marzilli, are incorrect and inaccurate. And when I further kind of reflect on things, the FDA had explained things to me during the court-ordered inspection that I believe would be relevant of why these people were, why it was skewed. Additionally, there was a morning and evening call on June 22nd with Milt, the Seacamp co-op out of New York, and with his calls with the FDA, they explained things. It would appear from the totality of things that I will get into, I believe that there would be issues of conspiracy to deprive rights and depriving of rights under the color of law. You'll notice that I was not mentioned in the statement of fact. You'll see that the named individuals' duties, if you examine this matter, you'll find that their duties were within the office. And it appears that this case, they were litigating issues within the cheese manufacturing. So it doesn't even appear that these individuals would have had direct knowledge of facts and were not within their typical duties. Further, there'd be issues whether myself, Antonio Gangale, was possibly the only individual with direct knowledge of many of the facts within this matter. I believe it would be unconscionable and inconceivable that I wasn't given notice in the case, and whether there was issues of depriving rights under the color of law. Further examination of it, you'll discover that the paragraph, or the phrase, after management and day-to-day operations of Union Cheese Company, you'll see that the statement, including the methods, manners, and conditions which Union cheeses are manufactured and distributed. So that appears to be omitted from the June 16th order. And I believe that's extremely relevant, a material part of statement of manufacturing that would give much more detail as to what they were seeming to suggest or imply within this paragraph. When you look at the facts and things, I believe it comes to become very ambiguous, vague, and a convoluted paragraph. I was with the FDA most of the times when they were within the facility. Some exceptions would be if I was called down or if there was emergency. Besides that, I was usually accompanying them during those periods of time. So I was with the Food and Drug Administration, the U.S. Department of Agriculture, and the Ohio Department of Agriculture. We'll get into this a little later. I believe it would be very easy to verify if these declarations are correct. Possible witnesses would be the named individuals, Dominic and Annette. There'd also be my mother, Dale M. Gangale. She worked there 18 plus years as a secretary, would have direct knowledge of many of these facts with regard to individuals' duties. Myself, the employees at Union Cheese Company, milk drivers, independent drivers, which are usually there daily or are there daily, with the exception of Sunday. The milk co-op, neighbors in the community, local businesses, U.S. Department of Agriculture, the Ohio Department of Agriculture. We'd also, many of the entities doing business with Union or after would have knowledge, or at least some knowledge, of people's duties. When I examined the declaration of John R. Marzilli, wondering how he derived these, so you'll see within here, it says the FDA prepared official records of these activities around the course of its business, familiar with the investigation of Union Cheese Company conducted by the employees of the FDA Cincinnati District Office. Official records of the FDA over which I have custody and control establish the facts in these declarations. These records include, but not limited to, establishment, inspection reports, collection reports, and correspondence between the FDA and Union Cheese Company. I believe with regard to these establishment, inspection reports, and collection reports, they're referring to Form 482 483 inspection observations, and 484 receipts of samples. I want to further mention that this statement, although she does not have a title at the plant, seems to come up throughout these declarations and things. So we'll see. These are just cut and paste to kind of give you some idea of these forms and how many were issued. You'll see name, and they'll say usually title or whatnot. So these were with my father. You'll see here, and these were with my sister, and it states, you'll see title, it says secretary. You'll see the dates. So I don't quite understand how he derived these facts. Here it says she's second in command at Union Cheese, is active in and authority over the management and day-to-day operations of Cheese, although she does not have a title. So I'm for the particulars of my sister, I've shown here. You'll see, and here the collector's name, the investigator. You'll see again Secretary Phillip. Here you see again secretary. So I just don't understand where they derive these declarations from. I was going, there were some files with the Ohio Department of Agriculture, but you'll see in 20587, you notice my mother and her title. So, well, we'll get a little further. My mother passed in 2019. In 1976, the couple purchased a small cheese factory in Sugar Creek, Ohio, together, growing it to among the largest in the state. Here it says job title, or excuse me, job of secretary and bookkeeper of the cheese factory. So you'll see within the declaration, I believe it says the company is a corporation organized under the laws of the state of Ohio. So within public accessible record, you'll see here, Dale, secretary, the corporation shall be named Union Cheese Company, secretary. You'll see here, certificate, again, secretary. Now these are public record through the Ohio business search. You see here, it says necessary. Ohio law does not permit one official to sign in two capacities. Two separate signatures are required, even though if it is necessity to the election of a second officer. So we're going to jump ahead just a little bit. We'll see that there are findings of fact within this case. This is the June 16th order. Here it has that Defendant Dominic Gangale is the president and sole shareholder of Union Cheese Company, with responsibilities for and the authority over the management and day-to-day operations of Union Cheese. When Dominic is not present at the plant, Defendant Annette Gangale assumes control of its operation.